The different types of economic customs regimes. The customs warehouse or bonded warehouse. Bonded warehouses allow goods to be placed for a fixed period of time in establishments subject to customs control. Customs warehouses may be authorized at any point in the taxable territory, where the needs of trade and industry make them necessary, subject to the possibility of control by customs officials. The only restriction is therefore the possibility of control by customs officials. A bonded warehouse is a system that allows companies, under customs control, to import or acquire duties and taxes under suspension, A. materials, equipment, and parts and spare parts thereof, B. goods intended for use in the manufacture of materials and equipment, C. goods, which do not appear in the compensating products, but which make it possible to obtain these products, even if these goods disappear totally or partially during their use. This is a system, which is the result of a combination of the advantages of the suspensive regimes of temporary admission for active improvement, temporary admission and warehousing, thus constituting, for customs purposes, a quasi-export-free zone. The compensating products thus obtained must be intended, in whole or in part, for export. The cases of fairs, exhibitions and other events. The premises necessary for fairs, exhibitions, competitions and other similar events may be set up as a bonded warehouse. A. The period of residence of goods placed under this procedure shall be limited to the duration of the event. B. A customs office is established within the premises of the warehouse. C. Goods, objects and materials of foreign origin intended for display or demonstration shall be admitted to a special public warehouse, provided that 1. That their identification is possible during subsequent export, 2. That their quantity is in accordance with their destination. These are generally samples, prototypes and specimens. 3. That their exclusive use is exhibition or demonstration. Consequently, these goods may not be lent, rented, used for a fee or transported outside the premises of the fair without the authorization of the customs authorities. The goods, objects and materials intended for the fair must be moved under cover of a detailed declaration of transit security. 1. On import, between the office of entry and the one opened inside the fair. 2. On export between the said office and the office of exit. Goods of foreign origin on display must be exported once the exhibition fair is over. These can also be declared for release for consumption after customs authorization. The temporary admission regime for active improvement. Temporary admission for active improvement is a system allowing goods intended for processing or additional labor to be imported, under suspension of the import duties, prohibitions and restrictions applicable to them, which make it possible to obtain new compensating products, even if they disappear in the whole or in part during their use. Such goods, after having received processing, working or additional labor, must, unless otherwise exempted by customs, be either exported, constituted in a warehouse or placed under the temporary admission procedure, before the authorized expiry date. Goods declared under this procedure for processing benefit, on importation, from the suspension of duties and taxes. The clearance of temporary admission accounts for active improvement takes place in the same way, that is, products exported, or constituted in storage or placed under the temporary admission procedure, called compensating products, must be obtained from the goods declared under the suspension procedure. This rule precludes the so-called equivalent clearance, in which goods, similar to those declared under temporary admission for active improvement, are incorporated into the composition of compensating products. The identical clearance is therefore mandatory. The entry of goods under the temporary admission procedure for active improvement shall give rise to the subscription of a receipt for security. This receipt is deposited with the Customs Office of Entry. A copy shall be given to the tenderer, and must be presented at any time upon request by customs officials. The verification of goods declared under temporary admission for active improvement must be the subject of visits by customs officers. The maximum period of residence of goods under the temporary admission for active improvement procedure shall be 2 years from the date of registration of the import declaration. The initial period of stay for goods under temporary admission for active improvement shall be 6 months from the date of registration of the customs declaration of temporary admission for active improvement. Any stay longer than the maximum time limit automatically constitutes an offense. In principle, the export or storage of the compensating products must follow immediately after manufacture, even before the expiry of the period normally allowed to the tenderer. The tolerance is provided for in the import and export. Tolerance is defined as the permissible deviation plus or minus in weight, length, count, etc. when discharging goods imported under the temporary admission for active improvement regime. Tolerances are allowed in the marketing of certain materials and products in order to cover variations and changes due, in particular, to physical and material phenomena, hygrometry, heat, salinity. Thus, goods are eligible for this tolerance under the following conditions. A. In the event of a deficit, 1. Within the limit of tolerance, coverage on the basis of recognized elements, without taxation or litigation. 2. Beyond this limit, assumption of responsibility on the basis of recognized elements with payment of duties and taxes on the deficit recorded and any penalties, in the absence of production of convincing proof, certificate of non-disembarkation, differential status on the manifest, etc. B. In the event of a surplus, 1. Within the limit of tolerance, assumption of the recognized quantities without any contentious consequences. 2. Beyond this limit, assumption of the recognized quantities without taxation. The Customs Office officials shall keep an account for each temporary admission for active improvement operation, which shall be annotated in particular. The quantities of goods placed under this procedure. The quantities of the compensating products, for which accounting declarations have been lodged and verified and, where applicable, quantities of goods released for consumption or exported in the state in which they were imported. These accounts shall be kept by weight, meter, volume, area or number depending on the type of goods placed under this procedure. The weight taken into account is the actual net weight, that is the weight of the goods stripped of all its packaging. The Customs may authorize the transfer of compensating products, irrespective of the degree of processing achieved by products imported under the temporary admission regime for active improvement. This measure tends to encourage the development of subcontracting of products manufactured in the country by different economic agents involved successively in the production of a given product. This is done by clearing the temporary admission account for previous active improvement. Regularization of temporary admission accounts for active improvement. In principle, the regularization of a temporary admission account for active improvement, to be done by exporting the compensating product. However, the export in the same condition, as the goods in the same condition, as they were imported may be authorized by Customs. The Customs may provide for the possibility for the tenderer to abandon for his benefit, or destroy goods placed under the temporary admission procedure for active improvement where, for duly justified commercial reasons, such goods cannot be exported or released for consumption, either in the unaltered state or in the form of compensating products. The destruction or abandonment must not entail any costs for Customs. The regulatory waste tax system. Regulatory waste is defined as manufacturing waste, whose percentages have been accepted by Customs on a declaratory basis. Regulatory waste can be A. Released for consumption or B. Exported or C. Destroyed under Customs control. The release for consumption and export of regulatory waste is legal. The abandonment and destruction of such waste shall be subject to prior authorization by the Customs authorities. In view of the specificities of certain sectors and the nature of waste specific to certain branches of activity, it was considered useful to introduce the distinction between recoverable and non-recoverable waste. Waste is considered irrecoverable if it has no market value. The regularization of this waste will be carried out without filing a customs declaration, free of duties and taxes. However, waste is recoverable when it has a market value, it being specified that the taxable value to be taken is that of the waste on the day it is released for consumption. The temporary admission regime. Temporary admission is a suspensive regime allowing the introduction into the taxable territory of a. materials and products that can be exported in the state in which they were imported after having received the intended use. b. objects brought by persons who have their habitual residence abroad and who come to stay temporarily in the country. Objects, materials and products declared under this regime shall benefit on importation from the suspension of the normally applicable import duties, taxes, prohibitions and restrictions. Subsequent export, after use in the unaltered state, of such articles, materials and products shall take place free of any duties and exit taxes normally payable. The purpose of this scheme is export. However, after prior authorization by the customs, these objects, materials and products may be stored in a warehouse. However, the customs may authorize the release for consumption of such articles, materials and products. It is also expressly stated that the export of these objects, materials and products must take place in the same way. The case of the objects brought by foreigners visiting the country. Persons who have their habitual residence abroad, and whose period of stay in the country does not exceed 6 months in the same year are eligible for temporary admission. A non-resident is deemed to be any person who can prove a valid residence permit abroad, a residence permit for holders of a foreign passport indicating residence abroad or any other document in lieu thereof. In addition, the customs authorities do not have to worry about whether the persons concerned come for tourism or to carry out a temporary professional activity. On the one hand, the number of objects in use corresponds to usual needs, carried by persons or contained in their luggage, accompanied or not. No exhaustive list can be drawn up, but the quantities and values of these objects must be assessed in relation to the social situation of the persons concerned. On the other hand, it is also specified that means of transport means any vehicle used to transport people, including horse-drawn carriages with draft animals, personal aircraft, motorcycles, caravans, etc. It is an offense to use such objects either by an unauthorized person, or for purposes other than those for which the scheme was granted. The use of autocarnets. The purpose of the Customs Convention on the Temporary Admission (AUTA) is to facilitate the completion of formalities relating in particular to the temporary admission of goods, under suspension of customs duties and taxes payable on importation, under cover of an international customs document evidenced by the autocarnet, which is an international customs document. The territories of the contracting states to the convention form a customs or economic union may be considered as a single territory. For temporary admission operations of goods covered by the convention, autocarnets must, under the conditions specified below, be accepted, a. instead of customs declarations, b. and as security for duties and taxes payable, under the conditions laid down in the conventions referred to in Article 3 of the AUTA Convention. An association approved by the customs authorities of a member state shall be designated for the issue of autocarnets in the territory of that country. A guaranteeing association shall be approved by the customs authorities to guarantee the sums due or implicated. Each guaranteeing association shall guarantee to the customs authorities of the country in which it has its headquarters the payment of import duties in the event of non-compliance with the conditions laid down for the temporary admission or transit of goods introduced into that country under cover of autocarnets. It shall be liable, jointly and severally with the persons liable for the aforementioned sums, for the payment of these sums. The goods eligible for the autocarnet system are a. goods intended to be displayed or used at an exhibition, fair, congress or similar event, b. educational and scientific materials. C. Goods to be used for tests, experiments or demonstrations. D. Representative samples of goods intended for presentation or demonstration. E. Professional equipment and animals necessary for the exercise of a trade or profession of persons coming to perform a specific work of limited duration. The AutoCarnet agreement covers the temporary admission of the goods mentioned above, intended to be re-exported in the same condition as they were imported. The conditions of validity of AutoCarnets. Issuing associations must indicate on the cover of the AutoCarnet the countries for which it is valid and the corresponding guaranteeing associations. In the event that goods admitted under cover of an AutoCarnet have not been re-exported under the conditions laid down by the Convention, the guaranteeing association shall have a period of 6 months to provide proof of the re-exportation of the goods under the conditions laid down or any other regular discharge of the AutoCarnet. If such proof is not provided within the prescribed period, the guaranteeing association shall immediately record such sums or pay them provisionally. Such deposit or payment shall become final 3 months after the date of the deposit or payment, if the guaranteeing association cannot be provided. In the event of destruction, loss or theft of an AutoCarnet, the national customs authorities shall accept, at the request of the issuing association, a replacement title, whose validity shall expire on the same date as that of the replaced carnet. In the event of fraud or abuse of the procedure, the customs authorities shall have the right to take legal action against persons using an AutoCarnet, to recover import duties and other amounts due. The triangular trading operations. These are commercial operations consisting of the temporary admission, with payment, of goods from abroad for re-export in the same condition as they were. Transactions of this kind are authorized, under the following terms and conditions. A. Production by the interested parties of the commercial documents justifying the proposed transaction, including in particular purchase and sales invoices, purchase orders, letters of credit. B. The duties and taxes payable must be covered by a bank guarantee or by their deposit. In the event that the imported goods do not leave the customs premises of the import office, the operation may be carried out with exemption from the requirement to produce a security, provided that a. The simultaneous submission of declarations of temporary admission and export. B. No certificate of origin is granted for these goods. And B. In cases where the initial import does not give rise to a transfer of the foreign exchange value, the operation may be carried out under the transshipment procedure, if the goods do not leave the customs premises. Temporary export for passive improvement or outward processing. Temporary export for outward processing can be defined as the inverse of temporary admission for active improvement. This regime allows the provisional export, under suspension of the duties, taxes, prohibitions or exit restrictions applicable to them, of products and goods of national origin, or released for consumption or imported under temporary admission for active improvement, which may be identified on their return, in order to receive, outside the taxable territory, working or processing. A distinction should be made between temporary export operations for outward processing for repair and industrial operations relating to contract work. A. Repair cases. These are devices or machines intended to receive repairs or tune-ups abroad, subject to the possibility of identification on return. B. Export cases for processing under contract. These operations relate, in particular, to contract work abroad: retreading, weaving, dyeing, tailoring, assembly, etc. The adjustment must be carried out in the same way. The presentation, on subsequent importation, of goods similar but not identical to those previously exported would result in the inapplicability of the scheme. For each provisional export for outward processing, customs officials shall keep an account which shall be annotated: a. The quantities, species and values of the products placed under this regime. B. The quantities of compensating products imported in clearance of the said account, or the quantities and values of products placed under the said arrangements and exported definitively in clearance of the same account. On re-importation into the taxable territory, products and goods of national origin or nationalized by the payment of import duties and taxes are taxed on the basis of the tariff type of the imported products and goods. Customs duties and other duties and taxes are those in force on the day the import declaration is registered. The value to be taken into consideration is that of these products and goods in the state in which they are imported, less the value of these products and goods previously exported. This value will represent the total cost of the operation, including transportation costs, the price of parts added or replaced, labor. However, release for consumption shall be effected with total exemption from import duties and taxes, if it is established that the working or processing carried out consisted of a repair carried out free of charge, either because of a contractual or legal obligation of guarantee or because of the existence of a manufacturing defect. Failure to re-import within the prescribed time limits products and goods temporarily exported for outward processing shall be considered as a definitive export, and shall result in the submission by the tenderer of a new export declaration and clearance of the one initially registered, with all the consequences arising from the export scheme, not to mention the contentious consequences for failure to fulfill the commitments entered into. The temporary export regime. Temporary export is a regime allowing exit from the taxable territory, under suspension of the duties, taxes, prohibitions or exit restrictions applicable to them, a. Objects intended for the personal use of persons habitually resident in the country, who are going to stay temporarily outside the territory, b. Certain materials, products and animals to be used abroad. Subsequent importation, after use as it stands abroad, of the objects and equipment shall take place free of all duties and taxes normally levied on importation. Finally, it is specified that the importation into the taxable territory of these objects, materials, products and animals must take place in the same way. The customs processing regime. The customs processing procedure is a procedure which allows the importation, under suspension of duties and taxes, of goods in order to subject them to operations, which modify the species or state in order to release them for consumption. The products resulting from these operations are referred to as processed products. This regime allows the manufacture and sale on the local market of products initially benefiting, on their direct import from abroad, from total or partial exemption from duties and taxes, pursuant to specific legislative texts. The system of processing under customs control is granted to persons having the necessary tools for the proposed processing. The beneficiary of the processing under customs control, a natural or legal person, who undertakes to comply with customs regulations, is called a tenderer. The goods to be used must be identifiable in the processed products. The agents of the underwriting office shall keep an account for each processing operation under customs control, which shall be annotated, in particular, a. the quantities of goods placed under this procedure, b. the quantities of processed products, for which detailed declarations of release for consumption have been lodged and verified. A processing account under customs control may be subject to a single global clearance or several successive partial clearances. Depending on the nature of the goods placed under the customs processing procedure, the relevant accounts shall be kept in weight, meter, volume, area or number. The weight taken into account is the actual weight, that is the weight of the goods stripped of all its packaging. The processed products shall be released for consumption under the following conditions. A. The duties and taxes payable shall be those in force on the date of registration of the customs declaration, according to the tariff type and the quantity of the processed product. B. The value to be taken into consideration shall be that of the goods on the date of registration of the declaration for entry of the said goods under the customs processing procedure. The transit regime. Transit is a procedure allowing the transport of goods in bond from one customs office or warehouse to another customs office or warehouse. goods in transit benefit from the suspension of duties and taxes, prohibitions and restrictions normally applicable. In reality, several cases must be distinguished. First case, goods from abroad crossing the taxable territory from a port of entry to a border exit office. For these goods there must be, at entry, suspension of duties, taxes, prohibitions and import restrictions. On leaving the country, non-application of duties, taxes, if any, export prohibitions and restrictions. Second case, goods originating from abroad and transported under the transit procedure from a port of entry to a customs warehouse or an inland office are subject to suspension of import duties, taxes, prohibitions and restrictions until their destination. Third case, compensating products obtained under the temporary admission procedure for active improvement, objects, materials, are transported under the transit procedure from the place of manufacture to the frontier export office. Goods in transit circulate under the cover of a receipt for security or special documents used under international conventions. The receipt for security shall be lodged at the customs office, where the transit operation originates. One copy of the receipt remains at the office and another copy is given to the bidder. The tenderer's copy shall accompany the goods, and must be presented at the same time as the goods. 1. During any inspection of customs officials along the way. 2. At destination, at the customs office or on arrival at the warehouses. Any incident resulting in a break in the seals or a change in the security measures affixed must be reported to the customs officers at the office nearest to the place where the incident was found. In case of any doubt, a customs declaration must be drawn up which will allow their verification. At the end of the journey, and at the office of destination, the goods may be declared for all customs procedures, and the goods declared for consumption are subject to the duties and taxes applicable to them. In the event of deficits being identified, the customs duties and taxes applicable are those in force on the date of recognition of these deficits. The drawback regime. The drawback system allows, following the export of certain goods, the refund to exporting companies at an average rate of the import duty, and possibly, of the domestic consumption taxes initially paid on the constituent materials and energy products consumed during the manufacturing process. This regime therefore arises at the time of the export of products manufactured in the country, in whole or in part, from inputs of foreign origin previously admitted after payment of import duties and taxes. This is a flat-rate refund scheme for duties and taxes paid on the importation of raw materials and semi-finished products used in the manufacture of exported goods. The flat-rate reimbursement rates shall be fixed by customs taking into account a. Taxation applicable to raw materials, semi-finished products and energy products used to obtain exported goods, b. Production data sheets that make it possible to determine the respective quantities of each of the components used, c. Results of surveys carried out by customs services and comparisons between several companies producing the same goods, d. Technical opinions from the ministerial departments responsible for the protection of exported goods, e. Opinions of professional associations in the sector. The refund file includes a. An extension of the export declaration bearing the services visa, b. A form called drawback refund request, c. Justifications for the prior import, with release for consumption of foreign materials used with drawback request, d. Any other supporting documents that may be required by customs and indirect taxes. The sums to be refunded are settled at the end of each quarter, and no refund may be made in respect of a previous export of more than 2 years.